hold on to your seats because this courtroom drama is about to explode. In this case, Ms. Harris, a defendant who's had multiple chances, is now facing the consequences of a long history of mistakes. She's pleading with the judge to be granted an opportunity to care for her sick child. But is the judge going to buy that plea after multiple probation violations, felony charges, and relapses? Her situation is complicated. She's already a convicted felon. She's had a rough year, and her family is dealing with significant health issues. But what happens when someone continues to make bad choices despite multiple interventions? We're about to find out just how far sympathy can stretch in the eyes of the law. The judge is about to drop some hard truths, and this decision could change everything for Ms. Harris. Stay tuned for some serious courtroom deep.
Mr. Rojas, you may proceed with argument.
Thank you, Judge. In the updated PSI, the recommendation, the last recommendation from probation is safety continuum.
Go ahead, I'm sorry.
And certainly, Ms. Harris is willing to do that. However, she would ask the court to consider something else given her circumstances. She's, as stated in the PSI, she's heard things about the JCDI program. She would like to have a chance in the JCDI program. Certainly, she feels that the reason that she relapsed was because she had some things going on in her life. She had a couple of cousins back last year that got shot, and her dealing with that herself and seeing the way it affected her mother caused her to relapse. But the reason she's asking for JCDI rather than safety, Judge, she's got a young child, a young daughter who has some medical issues. Her mom has been taking care, Ms. Harris's mother has been taking care of the child while she's been in custody, and the mother is here, the grandmother's here this morning, and I've spoken with her, Judge. When Chastity is out and she's taking care of the child, the grandmother says that she takes care of the child and she's tremendous help to the grandmother taking care of the child, and the child is going to need some surgery coming up. And the grandmother is being overwhelmed right now with that surgery and the medical issues. And for the child and the grandmother, more than for Chastity, Judge, we're asking for you to consider continuing her probation and considering JCDI rather than safety, just so that she can get out and take care of her child. I think Chastity wants to address that with you as well, Judge.
Okay, now the judge has just made a critical point. Ms. Harris is asking for yet another chance based on personal hardships, but the judge isn't moved. He's pointing out that she's already been given multiple chances, and it's not his job to cater to every personal crisis. Let's be real here. This isn't just about sympathy for her child or her family. It's about the choices Ms. Harris made and her refusal to take full responsibility. The real kicker? The judge makes it clear that her situation is a result of her own actions. That's a tough pill to swallow for anyone in a similar situation. When should personal hardship outweigh legal consequences? And is the law obligated to offer a pass just because someone has had a rough time? Drop your thoughts below. Let's talk about the fine line between compassion and accountability.
So here's the thing, though, Ms. Harris, and it's a bit frustrating to me. I feel for your family that is helping take care of your child, but it's not on me if you're not there to do that. And so using that doesn't really go very well with me, because it's you that put yourself where you are. You're a convicted felon. You've been given chances at probation that got revoked. You got time in prison. Then you are placed on probation and given this great opportunity for possessing a firearm while you're on probation. You get another case while you're on probation for the first unlawful possession. I give you another chance on probation with a possession of a controlled substance. I get the argument that you need help. I send you to SafeP. You do SafeP. You get out for ongoing support. You go through the drop program. Did well for a little bit, relapsed, and when you relapse, they're trying to get you more help, but there's just not, you've been on the high medium risk supervised caseload. You've been to safety. You have successfully completed the moral recognition therapy. You've been through the transitional treatment caseload, and you've been to the spinal top outpatient center. There's nothing else. You are making choices now that addiction at some.
Hold up. Did Ms. Harris just deny having a drug problem? After all she's been through, rehab, probation violations, relapses, and multiple chances, the denial is stunning. This moment is a major turning point. The judge is visibly frustrated, and it's clear. This case isn't just about addiction anymore. It's about accountability. The judge is basically saying, we've given you all the tools you need, but you're not using them. The big question here is this: can someone truly change if they refuse to acknowledge their problems? This isn't just a legal matter, it's a personal battle. Do you think Ms. Harris can turn her life around, or is the system doing its best and she's just not ready to help herself? Let us know your thoughts.
Point, you have to take advantage of the substantial tools that you've been given. Ms. Malfino?
I agree with you. Also, it's concerning to me that in the update PSI, she denies that she has a drug problem when clearly that's a big issue. And I do feel sorry for the situation
I do.
that she's in.
We're going to find, Ms. Harris, that again, you entered your pleas of true to counts 1 and 3, freely and voluntarily. I find those counts true. Also find count 2 true. Find sufficient evidence to find you guilty in each of your cases. And cause number 17-28222 finds you guilty of the 3rd-degree felony offense of possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 20-35466. What level offense is that one?
Here's where things take a major shift. The judge has found Ms. Harris guilty on all counts, and the punishment is severe: 6 years in prison. That's a tough sentence, especially when you consider everything she's been through. But the judge is not playing around. He's made it clear this is the consequence of repeated mistakes. The law doesn't give breaks just because you've had a hard time. It punishes for the choices you make, regardless of the circumstances. And now we see the stark reality. Her past behavior has caught up with her. The sentence is harsh, but is it fair? Does she deserve a second chance? Or is this what happens when you continually make the wrong choices? Let's dig into this.
It could get worse. You probably shouldn't talk. It could get worse. I had written down a higher number. So your attorney bought you, or your grandmother.
It's the second.
And cause number 20-35466 finds you guilty of possession of a controlled substance, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. They will run concurrently, which means together at the same time. I'm going to hand you, I need y'all to sign this, please. These were not plea agreements. You do have some rights to appeal. You need to sign that with your attorney showing that you have a right to appeal. And then I'll get you a copy of that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm.
Wow. Just when you think it can't get worse, the judge brings up some major issues with Ms. Harris's past. We're talking multiple felony convictions, probation violations, And to make matters worse, she's surrounded by others who are also making bad choices. This is really where it gets interesting. The judge is looking at the big picture. The people Ms. Harris is associating with are contributing to her downfall, and that's dangerous for her and society. But here's the twist. Could Ms. Harris have done better if she wasn't surrounded by negative influences? Could she have made better choices? This isn't just about one person's struggle. It's about the bigger, complex web of actions and decisions. What do you think? Does a person's environment determine their fate, or is personal accountability all that matters?
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. And here, good luck to you, ma'am. You can go back with the bailiff. So, Mr. Turner, you were just revoked back in October of 2021 and received a state jail sentence. Whose court was that in? Was that here?
Yes, ma'am.
So I know then for certain that I read to you those written admonishments about not possessing a firearm, right?
Yes, ma'am.
And you have a prior terroristic threat, you have a prior assault causing bodily injury, and you're walking around with some other young person with guns and shooting at random with hoodies on. I mean, then I've got 1, 2, 3, 4, 5, 6 in the last month and a half, 6 incident reports from the jail where you cannot follow the instructions. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily.
Now we're getting into the heart of the matter. The judge is denying Ms. Harris's bond request. Why? Because of her past. She's made too many bad decisions, and the judge is concerned that if she's released, she's just going to keep repeating the same mistakes. This is about more than just the crime. It's about the ongoing pattern of poor choices. And the judge is saying, I don't think you're ready for the freedom you're asking for. This is a tough ruling, but it's important. At what point do you say enough is enough? When do the mistakes stop being mistakes and become a pattern that can't be ignored? And can someone really turn their life around if they don't break out of their environment and circle of bad choices? What's your take on that?
Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an plea agreement that I followed, and so you've waived your right to appeal. I understand that you're fairly young, but you've been given some opportunities already, and obviously you're out there doing some things that could lead you to be in here for something much worse, where you've actually shot someone. It's just not, the running around with guns and shooting has got to stop, and all I can think of is the longer I can keep you away from society, probably the better at this point, because you can't learn. You haven't been able to learn from your past mistakes. I hope that you do, and I hope that you do this time and you get out and you change your life. But you're going to have to make those changes. There's help for you out there wherever you need it. There's help in TDC if you need it. But I don't feel like I have a choice today. I'm also handing you, just like I did before a couple of years ago, the written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you again. You should pay attention. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff. I feel like I've seen this. We have maybe one of the co-defendants that I
No,
did something
nothing
on.
I'm
This
aware
is
of, Your
very
Honor.
familiar to me.
Unfortunately, it's a pretty common fact pattern. It's 4 people riding around the car at 12:30 in the morning. There's 3 guns in the car.
Yeah. Okay.
And I'll just so the court's aware, the driver, Mr. Joseph Matthews,
Mhm,
who was charged with felon possession of a firearm for the firearm that's in the glove box of the car.
mhm.
He was on parole after taking a plea deal for the offense of tampering with evidence for his involvement in a homicide. Mr.
And that's a wrap. The ruling is clear. 6 years in prison for Ms. Harris. The judge has had enough of her excuses and sees her decisions as a pattern that can't be ignored. But what does this mean for her future? Will she ever be able to turn things around, or is this a case of too little, too late? The law is tough, but as this case shows, it's not just about the crime. It's about the choices you make, the patterns you follow, and the chances you take. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got plenty more cases coming your way. You won't want to miss it.
Dorsey, who fought with the police once they discovered a firearm in his waistband, is also a multiple-time felon. And then Mr. Sam has been convicted out of Harris County as a felon, as well as being on probation out of this court, Your Honor. So there was 3 guns in the car with these 4 people driving around.
In a deferred probation, motion to revoke a deferred probation, they're typically, you're entitled to a bond, but there is a provision that allows me not to. I think it's just based on the evidence, which is what I'll do. And if there's any other issues, we'll do it that way.
Judge West, can I say so?
Probably shouldn't. Mr. Sam, I'm going to deny your attorney's motion to set a bond in cause number 22-41263. Based on the nature of the underlying offense that you're on probation for, which is a robbery where you were allowed to plead to the lesser included in that case for a probation, and the fact that you have numerous violations, and one of those being a felon in possession of a firearm. Because you also have, it looks like there's a felony conviction that you have out of Harris County. So the fact that you had that conviction and got the probation already was, anyway.
That was essentially, I'll just let the court know that he was being held, he had a hold for that case.
All kind of at
while
the
we
same
handled the
time.
robbery here, Your Honor. I think he was transported back to Harris County after he pled on this case.
And got convicted in that case.
I believe so, Your Honor. I believe it is a final conviction.
Okay. And so based on the nature of the underlying facts that are alleged in that new offense, the fact that it is alleged that you were in a vehicle with several other people with at least 3 guns, other ones that are on parole and convicted felons as well. Obviously, all of that's a violation of your probation, I think, in the interest of the safety of our community. And based on all of the factors set forth in 17.15, I am going to deny that bail be set in this case. If you will get that other case fast tracked if possible, so that it can get go through the grand jury process. If something happens and that case is not indicted, then I will reconsider at that point. Mr. Rojas, I would allow you to file another motion and I would reconsider that. And then once that case goes through that process, if it is indicted, then I want to move as quickly as we can. If there's going to be a plea of not guilty in that case, and then it would probably be my desire to go forward on that motion first if we need to. All right, we'll take care of that the next court date. You can go back with the bailiff.